take up, please take November 2016 CPC question paper. Yeah, the first question is, yeah, have you got it, Mansi? November 2016. Yeah, what is a judgment? Huh? What is a judgment? The answer is section 2, subclause 9. So I won't be reading it. We read now. Huh? Judgment we read. Then second is, what is a foreign judgment? That is section 13 and section 14. Okay. We won't be reading it again. Now, how is the writ of summons served with the defendant residing in another state? The answer is section 28. Please go home and read it. A writ of summons residing in another, section 28 of the CPC. Then D, when cost awarded to court to a party to the suit, you have to check order, cost order 25, and also order 17 and section 35. These three are there. Please check these three relevant sections. Order 25 when security is given, then order 17 when adjournment is sought, then and section 13 the cost when the suit are dismissed or decreed. Then E, what is a precept in execution proceeding? Precept is section 46. This little explain to you. Section 46. This is a decree holder's application where the decree is transferred to another court, a transferee court. Under section 39 and section 42, we learned a transferee court, a decree transferred from a court to other court. Then when the execution court, namely the Bombay court, has passed a decree for execution which is sought to be executed in Delhi, they write a letter called precept for attaching the properties. This is only in the case of attachment of the property belonging to judgment debtor. Precept is given in case of attachment of the property of the judgment debtor belonging to him in another court, transferee court. Section 39, 42, please read it. This is relevant. Then next is what is the effect of a part payment of limitation? Section 19, padhe humne kal. When a part payment is made, the part payment made before the expiration of the limitation period. After it is made, it has zero value. The part payment should be made before expiration, then further period is extended, section 19. Then what is jurisdiction? So kal to padhe humne. Jurisdiction is, we learned it yesterday, that is the authority of the court to decide the matter, legal proceeding. The competency of the court to decide the matter. Section 9 mein padhe aapne. Please go to that. Then what are the inherent powers of the court? Section 155. When there is no provision specifically mentioned dealing with a situation in order to prevent the abuse of process of the court and to meet the ends of justice, section 151, all civil courts, high court, city civil court, Bombay High Court, small causes court, civil judge, junior division, senior division, all of them have inherent power. Whereas in CRPC under 482, only High Court has powers. Under 152, all the civil courts have the inherent powers. Then who is a pauper or indigent person? That we dealt yesterday under order 33, need not go. Then what is a abatement of suit? Now abatement of the suit, you learn abatement mean that is order 22 rule 9. Suspension of the legal proceeding, debarring a person, the suit being dismissed for having not brought the deceased person's heirs within time. What is the specified time? Within 90 days under Article 120 of the Limitation Act. If the plaintiff dies, his children should come on record, the heirs and legal representative. If the defendant dies, the plaintiff should bring on record the heirs and legal representative. Then under Order 22, Rule 10A, the duty of the advocate to give intimation. So here abatement takes place if the heirs are not brought within time. Please note that. Order 22, Rule 9, check kar lijiye aap. Yes.
Sir, in what is jurisdiction, do students also have to write about territorial and pecuniary jurisdiction and inherent lack of?
Yes, you have to mention all the territorial jurisdiction and local jurisdiction, inherent jurisdiction. Yesterday we discussed those aspect of the jurisdiction. Kal hi to hum discuss kar rahe the.
Yes, sir.
That you had given yesterday. Please don't note. हो गया. Then short note के लिए stay of suits and res judicata. Section 10 and 11. I gave you example of a Bombay suit and Delhi suit between the same parties. One is filing in Bombay for breach of agreement. Another is filing for giving effect to the agreement. So whichever earlier suit is filed, that will remain, and subsequent suit is filed, the defendant therein makes application for stay of proceeding. So there is no multiplicity of proceeding. Res judicata, section 11. We are given the detail res judicata that need not be again gone through. Then adverse possession and limitation. Now, adverse possession ke liye, you have to see Article 64 and 65 of the Limitation Act. The meaning of the adverse possession, I will just give you. Just give the meaning, a dictionary meaning. Adverse possession of land is the process by which title to another's land is acquired without his permission. Adverse possession is a possession which is opposed to one's interest of real owner's property. Then it is also, it's a possession. It is a possession in denial of the title of the true owner. So under section 27 of the Limitation Act, you learned that here, if the suit is not brought within limitation, the rights of the real owner are extinguished. Then Article 65 of the Limitation Act says that here, it deals with adverse possession. Adverse possession means a person who has trespassed into the premises against the wishes of the real owner and stayed there for more than 12 years. He is entitled to claim adverse possession. Okay, that is the meaning of it. Article 65, Article 64 is a adverse possession without title, and mean a person having possessory title only in possession and 12 years. Section 65, Article 65, a person it's a suit based on title. A person having no title claims title on the basis of adverse possession. Okay, then set off and counter claim. OCK आपने under order 8 rule 6 and 6A. Okay, set off is in respect of a ascertained claim, the character of the parties must be same. The amount which is sought to be set off must fall within the jurisdiction of the court. It must be the specified amount. Damages and unascertained amount cannot be claimed in a set off. Illustrations are there in order 8 rule 6 में check करें आप मिल जाएंगे. Then counter claim, the scope of the wider claim is much more wider. Any right or claim which is the defendant is entitled to can claim in a counter claim apart from filing written statement. It is a separate distinct suit. Of course, that cause of action must be within the ambit of the jurisdiction of the court. Then even if the suit is dismissed, counter claim and set off remains and the court can pass. They are independent decrees. And if you and the original plaintiff is required to file written statement to the counter claim and set off, failing which ex parte decree can be passed under the provisions of order 8 rule 9 and 10. That is there. Then next, appointment of a court receiver, order 40 of the Code of Civil Procedure. Before or after a decree is passed, court can appoint a receiver when just and convenient. Then another provision, appointment of a receiver is a section 94, supplemental powers. Then another provision for appointment of a receiver is section 51D in execution proceeding. These are the three provisions in CPC which we have substantially gone through, and you all know that. Then item number E, suits by and against government and corporation, section 80, 81, 82 and order 27. Section 80 mandates that here the suit against the government must be filed after giving 2 months notice, after expiration of 2 months notice. And notice can be dispensed with the leave of the court in cases of urgency. You know that here. Under section 81, you know that here the government officers cannot be arrested and they are not required to attend the court. Please note that here. There is a special class of exemption created for these people here under 81, exemption from arrest and personal appearance. Public servants are not required to appear before the court and they cannot be arrested during the pendency of the suit. But they can be arrested after the execution of the decree. In execution of decree, they can be arrested. Please note that here. Then order 27 lays down the procedure. If you are filing a suit against a public servant, like a police officer, custom officer, the Union of India or a state of Maharashtra or the concerned state are necessary parties. That you should know that. We have gone through substantially and need not to repeat it here. Then caveat provision is section 148A and order 40A for Bombay amendment. Please note that caveat means it's a application filed by a person against the another litigant, that no ex parte apprehending that some suit may be filed, some interim order may be obtained behind his back by suppressing material fact. So the applicant caveator requests the court that no ex parte orders be passed against me in any suit that may be filed by the other side, the opponent, caveatee, without first giving me an opportunity of being heard in respect of the subject matter. The validity is 90 days and it should be served by registered AD to the other side and inform the court. Okay, section 148 here. Please note that. Now answer 2 with reason. Number 1, Rahul wants to file a suit in the court today, which is the last day of limitation, but the court is closed due to holidays. Advise Rahul what Rahul can do. Will the suit be dismissed? So and so. Now let us see section 4 of the Limitation Act. Mansi, if you can open section 4, we'll be grateful to you, of the limitation. This section we have not dealt with earlier. Section 4 is the answer. If it's a Sunday, it's a holiday, and the expiration is taking place, the next opening day you have to file a suit. Next opening day immediately, what is on a Monday, after Diwali vacation, during Diwali vacation, your limitation expires. So that holiday protects you. But immediately on the first opening, under section 4, you must file a suit, limitation is extended. So here Rahul's suit will not be dismissed if it is filed the very first day of the next day. If you file second day, third day, fourth day, its suit is dismissed. Kindly note that. Then come to that Akshay has filed a suit against Bhaskar for recovery of immovable property based on the agreement of sale. Bhaskar, during the pendency of a suit, Bhaskar dies. Okay, number 1. Then what is Akshay's remedy? If Bhaskar's heirs not brought on record, what will happen to the suit? So here, when a defendant dies, the heirs are required to be brought on record within 90 days. Order 22 Rule 4 check karo uske andar. Please write it down. Order 22 Rule 4 and limitation period under Article 120 within 90 days. And if the heir, there is also one more provision to bring the heirs on record, that is section 146. You know that here. Then advocate has to give intimation under Order 22 Rule 10A. So your date of knowledge of the defendant must have died and gone in Dubai and America or London. You may not come to know. But his lawyer makes a statement that my client is no more. From the date of the intimation, 90 days, Article 20. If the application, suppose if he doesn't bring on record the defendant's heir within 90 days, despite having knowledge, then the suit will abate under Order 22, Rule 1, subclause 3. Please note that. Order 22, 1, subclause 3, the suit will be terminated. The suit stands abated. It has zero value. It as good as suit stands dismissed. Yeah. Next. Problem number C. John has given a loan of rupees 2 lakh to Peter. The limitation period for payment has expired. When John demands repayment for the loan amount, Peter gives an undertaking in writing to pay it after 6 months. Will the limitation extended by such writing? No. Section 18 of the Limitation Act says that writing given before the expiration period. Now here writing is given after obtaining a writing after expiration has no meaning, because there cannot be estoppel against statute. This particular matter came up for this nature under section 16 in a case before the Supreme Court. Write down AIR 1999 Supreme Court, page number 1047, or 1999 two Supreme Court cases 679. Party's name is Sampuran Singh. Sampuran Singh versus Niranjan Kaur. This is a relevant paragraph, is paragraph number 8 in that. That judgment I will just see if I can read it for you. Mansi, if you can open the judgment, I'll be grateful to you. Sampuran Singh versus Niranjan Kaur. The relevant discussion you will find of the Supreme Court paragraph number 9. Are you able to get it, Mansi? Sampuran Singh. Hello? Hello, Mansi?
Yes, sir. Just a second.
Sampuran Singh versus Niranjan Kaur. This is an important judgment under section 18.
Yes, sir.
Paragraph number 9 is there. See, yeah, in his endeavor, learned counsel for the appellant refer to section 18 of the Limitation Act. बिल आपको देखो, in his endeavor, paragraph number 9 है यहाँ पे judgment में. In his endeavor, the learned counsel for the appellant refer to section 18 of the Limitation Act 63 to hold that the acknowledgement by the original mortgagee to the respondent is by registered agreement 11/160. The limitation period is revived, which would only start from the date of the acknowledgement. Then the suit is filed in the year 1880 would fall with limitation. The said submission without any force, section 18 itself start with the word where before the expiration of the prescribed period for the suit or application in respect of the property, right of acknowledgement of a liability in respect of the property has been made. See that thus the acknowledgement, if any, has to be prior to the expiration of the prescribed period for filing the suit. In other words, limitation has already expired. It would not revive under this section. It is only during the subsistence of the period limitation, if any document is extended, and the limitation would be revived fresh and the set date of acknowledgement. So here Rahul has given, in this case here, John has given the amount 2,000 limitation, payment expired, John demands payment, acknowledgement is given in writing after the period. So the suit is barred by limitation. Okay. Now the second limb of the answer is here. Would it make any difference if the acknowledgement writing paid the payment before the expiration? Yes. The suit would be covered under section 18. It would be within limitation. Okay. Then write any essay type answer to for any 4. Now let us see. When does the court court issues commissions for what purposes? So under section 75 and order 26. You know that here. A very lengthy procedure. There are 4 or 5 commissions are issued by the court under section 75. I will not, because this topic we already dealt when we are dealing with substantially. I will just briefly recapitulate. Commission to examine any person, commission to make local investigation, commission to examine adjust account, commission to make partition, to hold scientific technical investigation, and to conduct sale of the property. 75 के अंदर A to F है. Then order 26 is quite lengthy procedure. Order 26 is commencing from order 26. Order 26 check करेंगे आप. Rule 1 से लेकर rule 22 तक है. This is a very comprehensive. Please remember section 75 on order 26 entirely. Please remember this. This is for commission. I won't be reading. We have done this. Then what is an interpleader suit? This we dealt under section 88 and section order 35. I won't again repeat it because in an interpleader suit, the plaintiffs have no interest, can only seek cost. It is where the defendants are more than 2 people. Then arrest and attachment before judgment. That is order 38, rule 5 and 6. So this is a interlocutory. Even before the suit is decreed, if the defendant is leaving the country, running away, and not likely to pay the money, and the court has power to attach his properties, ask for security. Order 38, rule 5 and 6. Kindly please go through order 36 is a comprehensive provision relating to that. Then some of the provision relating to execution also included therein. What kind of attachment the court can do that, and what attachment cannot be done also is given. Then provision relating to appearance of parties in a court, consequences to non-appearance and remedies available to the absent party. This is order 9, governs with the provision with regard to appearance of the parties. If the plaintiff appears, defendant doesn't appear, the suit will be declared ex parte. Only the defendant appears, plaintiff doesn't appear, the suit will be dismissed. Then application. These are the appearance must be there. If the plaintiff after appearing filing the suit, it doesn't serve the writ of summons, the suit can be dismissed. Okay, that you please go through order 9 very clearly. We have explained to you. Then remedies available to the absent party. Then what is limitation? What is the when it is extended by court? Now, limitation is a procedural law which prescribe limitation period for the filing of the suits and appeals and remedies. Extension by the court, section 5 of the Limitation Act gives you illustration when the limitation period can be extended in the cases of appeals and application other than execution application. Then section 6, 7, 8, 9, 10, 22 is the ground where the suit is barred by limitation, and what grounds you can take up is given to you in those sections. Then appeals to appellate court and Supreme Court. Appeals to appellate court, section 96 पढ़े हमने. Appeal to Supreme Court, section 109. Section 100, second appeal to the Supreme Court from the appellate decrees of the subordinate court, namely district court. Section 104 is orders, appeal from orders, and also order 43, appeal from orders. ये पढ़े आपने. Okay, this you remember very well. Then appeal to Supreme Court to be read, section 109 and order 45. Supreme Court, and certificate is given under article 134 of the Constitution. ये हो गया question. Anybody has any question now? So answer before I take up the next question. November 2015. Mansi, next question will be, question paper will be November 2015. Yeah. Anybody has any questions? Please ask me right now. समझ में आया आपको? Please sit with your pen.
Yes, sir. So actually, there's one quick. Sir, do answers have to be a particular length? We were discussing this last class, and then the session ended. Like for 12 mark answer, is it expected that we write a certain number of pages, and for 5 marks?
Yeah, you have to regulate your answer depending upon how many marks, how many marks are assigned. If the only marks are assigned 1 or 2, short answer. If the marks assigned are 10, 12, 8, and little substantially, you have to write little more material. That you have to, as a student, you have to edit your answer accordingly. You should know. Please read it. Ask good student like Mansi, she will tell you how to do that. She has been a very bright student, scoring good marks, and such student will be able to help you. And now she is a lawyer. Okay. Now next question. Now we are coming to November 2015. Question. Question. What is misjoinder of parties? Misjoinder is dealt under Order 1, Rule 9 CPC. Misjoinder, non-joinder, necessary parties. Who are necessary parties? There are two types of parties, no? Necessary parties and can anyone say?
Proper parties.
Yeah, proper parties. Proper parties need not come on record. Proper parties and necessary parties. Proper parties must be there. In a suit against trustees, all trustees must be joined. In a suit for partition, all the stakeholders must be joined. In a suit against government, Union of India must be joined. So they are proper parties. You cannot say that here. Proper parties must be joined under Order 1, Rule 9. Please check for us. Then what is an evasive denial? So the defendant has a right to file written statement within 1 month and maximum 90 days. His defenses must be very accurate and denying allegation correctly. Evasive denials are dealt under Order 8, Rule 4. Evasive denial is no denial. Denial must be very accurate and specific. Order 8, Rule 4 check kar lijiye ab rahega. Then next question, what is the prerequisite for filing a suit against government? See section 80 and Order 27. What is prerequisite? Giving of a 2 months notice, which is a condition precedent. That you remember. Under section 80, mandate that minimum 2 months notice must be given before filing a suit against government, because with a view to enable the government to settle the matter. So the public money is not wasted. Under section 80 subclause 1, the notice can be dispensed with the leave of the court. In cases of urgent matters, such as if you want to obtain interim orders. Otherwise, that is a mandatory. The next question is Who is a next friend of a minor? Order 32 rule 1 padhe aap. A next friend is a person who represents the estate of the deceased. He is a person who files a suit on behalf of the minor and who does not have any adverse interest. Itna answer rahega aapka. Adverse interest. Samajh gaya na aap? Order 32 rule 1. Then what is an order? Order is section 2 bracket में 14. Section 2 आप पढ़ेंगे यहाँ पे 214 के अंदर definition clause में वो दिया गया है. Order is में an order which is capable of execution. Section 2 subclause 14 में आप check करेंगे. Order means a formal expression of decision of a civil court which is not a decree. Order may be interlocutory order, an order rejecting the amendment, an order appointing a commissioner. So they are not decrees, they are merely orders. It is not a decision, it is not a decree. Okay, 214 padhiya. Then yes, sorry, कहाँ पे हम लोग आए? Yeah, 214. Then what happens? What happens when plaintiff is absent on the date of the suit is placed for hearing? Order suit is dismissed. Order 9 rule 8. The plaintiff is absent under order 9 rule 8. Court dismisses it. When the dismissal take place, he has to make application for restoration. Second suit is barred. You know that, no? Then who is the decree holder? Decree holder section 2.3. Decree holder means a person in whose favor a decree has been passed or an order capable of execution has been made. So execution proceedings LCK हमने order 21. Okay, that is the meaning of yes. What is the decree? Oh yes. What is the effect of acknowledgement? ये पढ़ चुके ना. Again acknowledgement section 18 आ गया. Then what is the effect of set off? What is the effect of set off mean? Set off which is dealt under order 8 rule 6. When a set off is filed, it should be in respect of a certain amount. Character of the parties must be same and within the same jurisdiction. The effect is if a decree is passed, the amount can be adjusted. Then next is what is a precept? Now dealt under section 46. दोबारा आया है. Precept is a letter written by the court, by the executing court to another court to whom the decree is sought for attachment of the property. To a transferee court, the executing court writes a letter, or requesting the court that the decree is sought to be transferred and the property of the defendant which is in the jurisdiction of that court may kindly be attached. Okay, that is called precept. Next is question number 2. Appeals against decree and order. That is appeals against decree section 96. Appeals against order section 104 and order 43. Okay, that we are dealt. Then mode of execution of decree and orders. That is mode of execution dealt under section 51 A to E. पढ़े ना हमने delivery of possession, attachment, attachment के बाद appointment of a receiver. वो सब देखे हमने any other mode the court ने. Section 51 पढ़ लीजिए आप. Then suit by or against corporation and firm. That is order 29. When a suit is filed by against a corporation, then the pleading to be signed by the officer, isn't it? Signed by the officer. Then firm is a partnership firm. आपने पढ़े section 31, order 31 के अंदर, all partners need not be joined, but the defendant says that here partners can be joined. A decree against a firm is binding upon all the partners. Then rejection of a plaint, E, order 7 rule 1, order 7 rule 11. Decree, the plaint can be rejected under circumstance order 7 rule 11 clause A, B, C, D, E, F. No cause of action. Stamp duty, proper stamps are not paid. Then barred by limitation despite the court removed. Order 7 में पढ़े हमने. Please check it up properly. Then extension of limitation period. When the limitation extended, section 5 of the Limitation Act. Under section 5, the court has power to extend the limitation period in respect of appeals and application, and not in execution application because a comprehensive procedure later. As regard the suit is concerned, court cannot extend it But in the suit itself, plain mein you have to make government. Okay. Suit in a representative capacity, order 1 rule 8. Boliye, person can sue for himself and on behalf of the others, obtaining the leave of the court. It's a representative suit. For example, suits under section 91, 92. More than 2 persons, they obtain the leave of the court, or they obtain the permission from the Advocate General to file the suit here. So they are representative characters. It is not only for the benefit of the plaintiff, but for benefit of general, almost everybody. Okay, that we are dealt with it. Next is a solve 2 problem. A and B enter into a contract of sale of goods by A to B. So A sells to B. Then the contract is made at Mumbai. The goods were delivered from Chennai. Payment of the price is to be from Delhi. B fails to pay the price, dispensing delivery of goods. A wants to file a suit, recover the price from B. In which court he can file a suit and why? The answer is illustration number A and B to section 20. So he can file the suit either in the place where the cause of action accrued, that is Mumbai, or delivered to Chennai, or in Delhi where he was residing. So under section 20 सीखी आपने, where the defendant reside or the cause of action accrue. If it is a defendant is not residing in particular occasion, cause of action accrued, leave of the court to obtain under section 20 of the CPC. If it is in High Court, under clause 12 of the latest patent. Okay. Then B. C has taken a loan of rupees 1,50,000 from D against promissory note after executing after the limitation period is over. C gives writing signed by him, stamp paper to acknowledge the loan. Now this will be coming under section 18. Here you cannot obtain the writing after the limitation period is over. The writing should be obtained before the limitation. The suit is barred by limitation. Okay. The writing must be obtained prior, please. That we just now dealt with the judgment of the Supreme Court I gave you right now. That is Sampuran Singh's versus Niranjan Kaur's case. Remember it here. This question has been very often repeated. Now next problem is Mr. A and B have filed a suit against CD. The court has fixed 8 October 2011 for hearing when the plaintiff and the defendant are present in the court at the time and the suit is called. C and D defendant is absent, his advocate is present. D has suffered a heart attack but could not inform his advocate on his date, could not inform the court. The court passes an ex parte decree against CD. What is the remedy of Mr. C? Remedy is under Order 9, Rule 13 to make an application for setting aside the ex parte decree within 30 days. You know that limitation under Article 123, isn't it? Then what would have happened if the plaintiff and advocate also remain absent? If the plaintiff also remain absent, the suit would have been dismissed. See Order 9, Rule 12, read with Order 9, Rule 8. Order 9, Rule 8 deals with the plaintiff absent. Order 9, Rule 12 deals with the absent of plaintiff and defendant. When both are remain present, it's the discretion of the court to dismiss the suit or to keep it give a next date. Okay, that is dealt with. Then next is write a short notes. Stay of suit and res judicata, section 10 and 11 we already discussed. Then creation of ownership by adverse possession under the Limitation Act. That is Article 64 and 65. Told you that if the real owner has not taken action against the trespasser within 12 years under section 27, all his legal rights are extinguished to the property. So the trespasser in possession can defend the suit under Article 65 on the ground that he has become owner by adverse possession, or he can also file a suit by virtue of the doctrine of adverse possession. Article 65, please note that. Then reference, review and revision. वो पढ़े हमने section 113, 114, 115, order 46 and order 47. I need not repeat it again. We have discussed it. Summary suits and procedure, that is under order 37, rule 1, 2 and 3 हमने देखे हैं. In a summary suit, when the plaint is lodged on hundis, bill of exchange, or bounce checks, or admitted amount, defendant cannot file a written statement as a matter of course. He has to obtain the leave of the court by filing his appearance within 10 days. If he doesn't file appearance within 10 days, the judgment will be passed against him under Order 37, Rule 3 of the court. That is, it's a summary proceeding, and no effective trial, no examination, cross-examination take place here. Then writ of summons and mode of the services. Now, writ of summons are dealt under the provisions of Section 27 and to 29, Order 5, Rule 1 to Rule 30. Please go through very well. Various person, how summons are served. Order 5 is very important. Order 5, Rule
1 to what rule?
1 to 30. 1 to 30. 30 rules and scandal. Order 5 is very vast. To various person, defendant who is in territory of the territorial of the court, the defendant who is outside the court, foreign country mein hai, defendant who is in jail, defendant who is in the military service. So please, comprehensive, please read it. We are dealt with it. Then substituted service under Order 5.
All 30 rules have to be written, sir?
And not written, just go through that.
Okay.
Summarily you mention, you can say that here, here you can mention since because they are asked 48 marks are there. You have to mention at least two lines of each. Two lines of each. Section 20. वो डालना पड़ेगा आपको. Please go through that. Just write one line on each. Here, writ of summons can be served personally upon the defendant. Number 1, or by email it can be done now. It can be done by registered post. It can be done by electronic modes. It can be through a jailer when a person is in jail. It can be through a court of law when the defendant is in outside Bombay. When he is in Bangladesh and Pakistan, through a court in Pakistan, Bangladesh, and not the High Court. That is mentioned there. Everything is mentioned there. In the Order 5, it's a comprehensive. When defendant is avoiding service, substituted service under Order 5, Rule 20. This I had discussed with you in all matter.
Yes,
please
yes, sir.
Okay. Anybody has any question now? We are finished now.
Sir,
Yes, suit by against corporation that we are dealt with in the Order 29.